Welcome to this explainer. I want you to start by thinking about the smartphone sitting in your pocket, or maybe the one you're holding right now. Think about what's actually on there. It holds your name, your personal photos, your daily location, and even your most sensitive bank details. And pretty much every single app you download wants a piece of that data. So who exactly is keeping all of that data safe? Who's protecting your personal life from these apps that constantly hoard your information? Well, for a long time in India, the answer was honestly a bit murky, mostly relying on some pretty outdated rules from back in 2011. But that has completely changed. Enter India's first dedicated privacy law, the Digital Personal Data Protection Act, or the DPDP Act 2023. This law is basically the ultimate shield for your digital footprint, and today we're going to unpack exactly how it works. Now, we didn't just get here overnight. This journey actually started way back in 2017 with the landmark Puttaswamy judgment, which is when the Supreme Court of India officially recognized privacy as a fundamental right. Fast forward through years of drafting and debates, and the DPDP Act was officially passed by Parliament in August 2023. But a law needs actionable rules to actually work, right? Well, the government notified those detailed rules in November 2025, bringing the whole thing fully to life, and the clock is officially ticking. Businesses have until May 13, 2027 to achieve full compliance. So here is our roadmap for this explainer. First, we'll look at the key players. Second, your new rights. Third, the business rulebook. And fourth, the high stakes and penalties. All right, let's dive into Section 1, Key Players. Before we can truly understand the rules of the game, we absolutely have to decode some of this dense legal jargon into plain, everyday English. There are two foundational terms you need to know for the entire act. First is the data principal. That's you, the actual person whose digital data is being collected. Second is the data fiduciary. That's the company, the app, or the website that decides how your data is actually going to be used. Think of it like this. You are the data principal, and your absolute favorite online shopping app, they're the data fiduciary. But this ecosystem also relies on a supporting cast. A data processor is really just a vendor, like maybe a cloud storage provider that helps the fiduciary process your data. Then you have a significant data fiduciary. That's a massive company that carries extra, much heavier duties, like having to appoint a data protection officer and run independent audits. But honestly, the most fascinating player here is the consent manager. This is a completely unique platform registered with the Data Protection Board. It acts as a master control panel for you, so you can manage, give, or even withdraw all your data permissions across totally different apps, right from one single place. Moving right along to Section 2, your new rights. This is honestly the most exciting part because this law hands ordinary people brand new, highly usable superpowers over their digital footprints. The crucial takeaway here is that you are no longer powerless. You now have 4 main rights. First, the right to access information. You can literally just ask a company exactly what data they're holding on you. Second, the right to correction and erasure. Let's say a shopping app has your wrong phone number. You can force them to fix it. Or better yet, you can tell them to delete your details entirely. You also get the right to grievance redressal if you feel you're being treated unfairly, and the right to nominate someone to act on your behalf. Oh, and companies have a strict time limit, often up to 90 days, to actually reply to your requests. But, of course, with great power comes a little bit of responsibility. The Act makes it very clear that your new powers come with basic duties to keep the whole system fair. You must provide true and correct information, you absolutely cannot file false or frivolous complaints, and you must never impersonate another person. It's a two-way street designed to keep everyone protected. Let's pivot to Section 3, the business rulebook. Now we are getting into the heavy lifting. The obligations placed on businesses are strict, and compliance is absolutely mandatory. It does not matter if you're a giant multinational bank or a small digital storefront. If you handle digital personal data, you are on the hook. So let's look at the core operational shifts companies have to make. First, they must give plain notice. No more hiding behind 50 pages of tiny legal jargon. They have to tell you what data they're taking and why, using simple words. Second, they must obtain valid, specific consent. And listen to this. Silence, or those sneaky little pre-ticked boxes, those do not count anymore. Consent has to be a clear, positive action. Third is data minimization. They can only collect exactly what they need for that specific purpose. And fourth, they have to keep that data locked down and secure. The law also takes a very aggressive, protective stance on minors. Under this act, anyone under 18 is classified as a child. Before a company can even process a child's data, they must obtain verifiable parental consent. But it actually goes further than that. There is an absolute blanket ban on tracking children, profiling them, or targeting them with ads. Mobile games and apps can no longer profile young users at all, which creates a vastly safer online space for kids. We also have to talk about how data moves around the world. For cross-border data transfers, India has adopted a negative list approach. This is actually really great news for global apps because it means transferring data abroad is just allowed by default. For example, a company can freely send data over to servers in Singapore. They only have to stop if the Indian government specifically adds a destination country to a restricted negative list. Which brings us to Section 4, high stakes and penalties. To make sure these rules aren't just empty words, the law created a seriously powerful watchdog, the Digital First Data Protection Board of India. And let me tell you, breaking this law gets incredibly costly very fast. 250 crore rupees. That is the staggering maximum penalty for a single violation. This incredibly stark number highlights the catastrophic financial risk businesses face if they fail to keep our personal data secure. This is definitely not a slap on the wrist. It's a massive financial blow. Let's actually break down this tiered fine structure. If a company completely fails to secure personal data, that's where the 250 crore maximum fine comes in. If they suffer a data breach and fail to report it quickly, or if they fail to protect children's data by tracking or profiling them, they're looking at a massive 200 crore penalty. Even just failing to meet basic duties or ignoring consumer rights can trigger fines up to 50 crore. The board will decide each fine case by case, weighing the actual harm caused and the company's intent. So for any business owners tuning in right now, waiting until May 2027 to overhaul your systems is a guaranteed recipe for disaster. Here's a rapid-fire checklist to start executing today. First, map your digital data. You need to know exactly what you have. Second, rewrite your privacy notices into plain, easy-to-read words. Third, fix your consent systems so there are no more pre-ticked boxes. Fourth, plan your breach response processes right now so you can report leaks immediately. And finally, train your team on basic data safety. The early movers are going to save themselves a massive amount of stress and potentially some massive fines. Which brings us to our final thought for this explainer. The DPDP Act of 2023 totally rewrites the rules of the digital economy in India. It empowers you, the user, with real actionable rights, and it places undeniable duties on the companies that are profiting from your information. But the real test isn't just about a company avoiding a 250 crore fine. It's really about culture. Are businesses truly ready to embrace this law as an opportunity to respect privacy and earn lasting digital trust? Or are they just going to view it as another annoying legal hurdle? The next time you tap I agree on your screen, just remember, the power is finally shifting back to you.